Hi, and welcome back to another episode of Ex Ante. My name is Alex Dolphin, and today we're going to discuss the case of United States versus Causby. And I know what you're thinking, this isn't Bill Cosby, it's spelled differently. Okay, and this case was argued in the Supreme Court of the United States in the year 1946. Causby was owner of a commercial chicken farm near a small airport in North Carolina. The small airport began to contract with the United States government to allow military planes to fly into their airport. Well, these military planes came very close to Causby's chicken farm, so close that it was only 83 feet above the ground where his chickens were laying eggs and eating seed. So Causby was distressed, as were his chickens. Over 150 chickens died due to the sound, noise, lights, and just the hardship that the planes had placed on their life. So he brought suit in the federal court of claims, arguing that the United States government had taken his property by beginning to fly military planes so close to the ground over it. The Court of Claims found in favor of Causby and granted him recovery of $2,000, stating that what the United States government had done by flying planes so low over his property had amounted to an implied contract and was truly an easement on his property. The United States wasn't thrilled with this, so they went ahead and appealed it. So let's go ahead and discuss the issue and spell that out. Specifically, it's does flight noise and lights over one's property by the government constitute a taking under the Fifth Amendment? Let's go ahead and jump into the ruling, which was written by Justice Douglas. He discusses the value of property rights, notes very briefly an old common law conception which stated that you as a property owner own everything above you and everything below you, then further spells that out as a theme that has changed in the law as airplanes began to use airspaces, travel space above people's property. So he doesn't say that Causby has no right to remedy, however. He says because the planes were flying so low and so close to his property and shining lights, as well as making intense noise, they actually had in fact taken his property to some extent. He stated that there is an extent to which a property owner has a right to the airspace above their property, but it's not the old common law conception of an infinite space extending all the way throughout the universe. So what the ruling of this case basically tells us is that although property rights are certainly not infinite above one's property in the airspace, there is some degree to which folks have rights in the airspace above their property, especially concerning planes that might make bright lights and loud noises, interfering with one's ability to properly enjoy their property. So let's go ahead and jump into some of the ex-ante implications of the case. So I want to think about drones, something that's widespread in our society now. Are drones analogous to planes in this case? If the United States was flying drones all over your property, just surveilling, would that amount to a potential taking? Drones aren't noisy, but they might interfere with one's ability to enjoy their property if one feels like they're always being watched by another. So I think perhaps a plaintiff against the government could argue that drones in their airspace are an infringement upon their ability to enjoy that, especially if those drones were surveilling the individual. Let's think about flying cars and jetpacks. Flying cars and jetpacks might seem far off, but I'm sure there will be a day where we have something analogous to a flying car or a jetpack, whether that's used in the ordinary day-to-day or whether that's something just for fun. Can the United States government or other individuals have a causeway over your property for flying jetpacks or cars if it interferes with your ability to enjoy that property? Well, probably not at 83 feet, as the court ruled in this case, but where is that line drawn, right? So if the cars were up 300 feet and the noise was a bit more faint and the lights weren't quite as bright, would the court not find in favor of a plaintiff in that case and say that the airspace above there is general and owned by the United States? Something to think about here. Because that line isn't drawn distinctly at a certain point in the air, the court left a lot of gray space to be filled in with future rulings as more objects and products begin to navigate the airspace. Now we've talked about airspace, let's think about an ex-ante implication of ground space. Elon Musk is all about these hyper tunnels right now. He's talking about how they're the future of transportation. Well, if a hyper tunnel, or Elon Musk's company, or if Elon Musk were to contract with the United States government and they built tunnels underneath everyone's property, and they had to go underneath your property in order to get somewhere most efficiently. If that was low enough that you felt maybe the ground vibrate and shake a little bit when the train or the cars went underneath you in that underground tunnel / highway, would you have a claim under the Fifth Amendment that what had been done to your property constituted taking? Definitely something to think about, and I think that a good attorney could argue that that would constitute a taking as well, just on the basis of the ruling here in the United States versus Causby. So thanks so much for watching. I hope you have a nice rest of your day. If you have any other ex ante implications, feel free to leave them in the comment section below. Goodbye.